Dr. Machiko Kanetake. Dr. Kanetake is Assistant Professor in Public International Law at Utrecht University and a visiting fellow here at the Transnational Law Institute of the Dixon Poon School of Law. Machiko, welcome.
Thank you for having me.
You've written about the rule of law as it relates to the bodies of the United Nations, which, of course, in a sense, hover above domestic law of any one country and present an interesting challenge in that case. In 2012, the UN General Assembly passed a resolution which stated that international law applies to the UN and its principal organs. Can you just take us through the context of that decision?
So, traditionally, the idea of rule of law has been considered as applicable to state, so the governmental authorities such as executives and ministries and the officials working for the government. But over the years, especially the United Nations and Security Council and Security Council subsidiary organs, they have started to exercise their authority against individuals as if they are government. So there are sort of increasing similarity between what the government has been doing before against individuals and what United Nations or other international organizations has been doing. So that's kind of the sort of historical background, and then leading to the adoption of UN General Assembly resolution that somehow trying to apply the idea of rule of law not only to government but also to international organizations, including or especially United Nations.
And when we talk of rule of law at the United Nations level, it's generally meant to encompass a rather formalistic view of its contents. Is that the case, or is it more ambitious than that?
So I think the development of rule of law vis-a-vis international organizations or United Nations has been quite sort of still in the early stage. Therefore, the applicable rule of law notion, the rule of law notion applicable to international organizations has been quite formalistic. So starting from the sort of the notion of legality, just to make sure that international organizations are acting within their power conferred by member states. So I think it would take many years, perhaps, before we start talking about more substantive criteria of rule of law, meaning the content of law, not necessarily sort of the formal legalistic standard.
Yes, and when it comes to applying the rule of law to the United Nations, the Security Council presents a particular challenge, doesn't it?
Yes, so especially within the context of UN targeted sanctions. So targeted sanction is one of the sanctions applied by UN Security Council, and the targeted sanctions was against the background of the criticisms of comprehensive sanctions. For instance, the sanctions against Iraq that has caused a massive humanitarian negative consequences on civilians. So therefore, especially from Haiti sanctions in 1994, the Security Council has started to apply more targeted sanctions against the individuals and entities. So the UN Security Council, and then more often by its sanctions committees, so they designate specific individuals and entities as a target of asset freeze or travel bans or any other restrictive measures. So that targeted sanctions definitely minimize humanitarian consequences on civilians, but at the same time that has been criticized because of the lack of due process at the level of the UN. So that's the sort of the one instance, and that's sort of one of the broader criticisms leveled against United Nations and international organizations in terms of non-compliance with human rights.
And when we talk about targeted sanctions, what form can they take? What do they require member states to do?
So the UN Security Council and its Sanctions Committee, they designate specific individuals. So what member states have to do is to normally use somehow executive order, and they ask banking communities, banks and financial industries to monitor their client information and ask them to freeze the asset or the account bank of the designated individuals. So actually the consequence is at the domestic level. Whatever UN Security Council say, everything has to be done by member state. But member state has very little control. All the individuals are already designated by UN Security Council and Sanction Committee. Therefore, it was very difficult for member states to comply a UN Security Council resolution and at the same time try to meet their human rights obligations.
So there can be potentially very serious legal consequences for the individuals, the subject of these bans, and it's essentially a result of a very high-level political process with not too many checks and balances around it. I mention this because often when Security Council reform is discussed, what people are talking about is changing the composition of the Council and changing the permanent members, but it's very interesting to think about the ideas of reforming the process as well, which seems to be an ongoing debate.
So this is also part of the rule of law debate that we discussed in the first place. One of the sort of principles within the rule of law is the idea of the separation of powers. So the idea of separation of powers has been accepted in many countries at the domestic level. So we, especially in this sort of developed world, we take it for granted. But that notion is not necessarily applicable or not applicable in the same way when it's come to the international organizations such as the United Nations and its organs, including the Security Council. So these targeted sanctions and then control of the authority exercised by United Nations Security Council is a part of rule of law debate.
If we could just change topic, another area that you've written about in terms of transnational or international regulations having an effect at the national level is transnational science-based standards. Could you talk us through what you're referring to there?
So one of the research projects I have been working on is interactions between the domestic law and international law. So within that framework, I have been expanding my research into the interactions between transnational standard and the domestic legal order. So my present focus has been on transnational science-based standard. So what I mean by transnational science-based standard is, first of all, the involvement of many transnational as well as governmental institutions. So there are so many standards, for instance, a standard based on a standard for food safety, chemical safety, and radiological safety. They are formulated at the transnational level through the dialogue and sort of discussion among not only research institutions, but also intergovernmental bodies, international commission of experts, and also international organizations such as United Nations. So those both scientific as well as political institutions, they collectively formulate the standard based on scientific data. So it's very difficult to locate who has played a part in setting the standard. And also, the standards are not only scientific. You need to, in order to decide a chemical safety standard, you also need to think about to what extent, what kind of risk you are willing to accept. So standard setting processes are not only scientific, but also highly political. So my focus is trying to identify not only the kind of standard, but also the various different actors which are collectively strengthen transnational or international science-based standard, and what kind of scientific as well as political considerations are injected into the standard setting processes.
And this process of a standard being arrived at the transnational level, possibly by an intergovernmental committee, possibly by a group of scientists, and then downloaded or imported into national regulation, has proved very controversial, for example, in the case of Japan.
That's right. So one of the sort of motivation I started doing with my research was the case of Japan. So I am Japanese. So after Fukushima, Fukushima nuclear power plant incident in March 2011. So after the crisis, the Japanese government started to employ international standard concerning the dose limit. So usually, if there is no crisis, there is a sort of a statutory limit as to the maximum dose limit applicable to individuals, which is 1 millisievert. Millisievert is a unit of radiation. So after the crisis, after Fukushima crisis, the Japanese government needed to raise that dose limit from 1 millisievert to 20 millisievert. And in order to strengthen their decisions, or in order to sort of convince national audience, one of the reasons why the Japanese government employed was the existence of transnational standard. So there is a committee called International Commission of Radiological Protection. It's called ICRP, which was established in 1920s. And then the ICRP has been very influential. And one of the influential recommendations that ICRP has adopted is a recommendation on dose limits. So after Fukushima crisis, the Japanese government employed ICRP standard in order to convince domestic audience and saying, well, as long as International Commission recommends this is a safe standard, this will be okay. So I was quite, in a way, concerned and disturbed by the use of international standard without considering the domestic context as well as political implication of using that standard in specific domestic context.
And I mean, this concern was widely shared, and in fact there are a number of court cases following that decision, were there not?
So there are a number of domestic litigations concerning Fukushima nuclear power plant incident, but one group of litigation is about somehow the health effect of radiation exposed to individuals. So there was a litigation, sort of the collective litigation brought by the children of Fukushima, and they challenged the decisions of the government and asking the government to evacuate the children affected by nuclear power plant crisis. And so the litigation itself is about the governmental decision making, but indirectly this litigation somehow indirectly challenge the standards set by international commission as well as other transnational institutions, which were adopted somehow utilized by the Japanese government in order to raise the dose limit from 1 millisievert to 20 millisievert.
And just as a counterpoint, it raises an interesting question, doesn't it, about the basis on which a court, domestic or otherwise, can challenge the conclusions of a scientific authority. What justification is given for departing from deference to such authorities in areas where the court has no particular expertise of its own?
So I think as you pointed out, one of the broader schemes of my research about interactions between transnational science-based standard and the domestic legal practices is to critically somehow analyze the governmental difference to transnational standard. And as I said, those transnational science-based standards are strengthened by the decentralized network of scientific institutions, intergovernmental organizations, and international organizations. So it's somehow understandable it's very easy for national governments to rely on international or transnational standard when they have to explain to the parliament or the domestic constituencies. So my research would be on and has been on what basis national government adopted transnational standard, and on what basis the citizens as well as national parliament criticize the governmental reliance on transnational standard, and both on scientific as well as political basis.
Well, Machiko, can I